Good day, liberators and fellow South Africans. At last, slim het sy baas gevang. That was exactly what happened with the Minister of Health and, in particular, government as a whole. You've seen that there's a letter circulating from the office of or from the Health Minister himself, purporting that he is considering to uplift these COVID-19 measures and, in particular, the compulsory mask wearing. People, there's a lot of issues that social media and the general mainstream media do not tell you. And the image out there is as if this was a voluntary decision and a decision that was thought through properly by the minister and the cabinet. But that's not the fact. What happened in the court cases, and as you know, that Liberty Fighters Network was the first one to lodge the court case challenging these amendments to the health regulations on the 6th of May, nearly 2 days after its promulgation. Other organizations, AfriForum, DSA, Solidarity, Sakeliga, all followed suit afterwards. So there was a decision by the acting Judge President Ledwaba to combine these 4 cases, and that it would be argued on the 25th to the 27th of July before a full court in the High Court in Pretoria. I will come back to that. But what is important here is that let me just give you a background and say why we believe that the minister had no other alternative but to do what he is allegedly planning to do, and hopefully he will pull through. We've received a letter this afternoon from the State Attorney's Office asking permission that the minister must file his answering affidavit by Friday the 24th, pending the decision by Cabinet on Thursday. So that is tomorrow. Because obviously they believe that the decision might influence the answering affidavit. Now, the short and the long is that the minister was supposed to discover his full record to court pertaining to the decision that he has taken to promulgate the amendments to these health regulations. Now, when we received it, it was a total paradox in itself. Firstly, it was incomplete, and secondly, it was over-exaggerated. It was so large, it consisted of something like more than 1 million pages of information. Now, so firstly, we said, okay, but this record does not make any sense. We would like you to provide us with a hard copy of it. Alternatively, on the court's case lines database system, you must upload the PDF version of all these pages. So all the pages must be in a PDF format or image format so that it's easy to access. But what the ministers or the attorneys, specially sourced by the State Attorney's Office to compile this record did, was that they've uploaded the record onto the case line system, but it had links into external databases as well. So then we said, but this cannot be a correct record, because if, for starters, if we were still in the times before the case line system, the minister would not have thought for 1 minute to produce such an extensive millions and millions of pages of a record. It would have been precise, concise, and to the point, and only those that have been taken into consideration in order to make the decision. But now, unfortunately, with the case line system, it has opened up a Pandora's box, because now the minister, the government can now come in and they can upload these records, and it can be a total mess of information that they would never have consulted, but because of the magnitude of it, they can then say, yeah, but they've done a proper job because they have consulted all this. And then it's up to you as the applicant and as the public to then come up with and sniff out what is actually part of the record and what should not be. So only us, who are not represented by legal practitioners, started to extensively query this record and the content of it. Yes, some of the other attorneys have raised their views, but it was very it was only to the top, and not to the actual problem. I will come to that as well now, why they would have done that. But in any event, so we said no, this cannot be a proper record, and what we did was, and very importantly, is that the minister informed all the parties that some of the documents or records have not been discovered because he relies, or the Minister of Health relies on attorney-client legal privilege. Immediately, we jumped on the bandwagon and we said, no. Um, Government cannot rely on attorney-client legal privilege. Number one, the state attorney's office is not, or the minister is not the client of the state attorney. The state attorney is, in fact, a governmental department serving the government. And secondly, that if a legal practitioner might rely on on client or attorney-client legal privilege, then it only resorts to the legal practitioner. But the minister or government is compelled by the Constitution to be fully transparent and to provide the full actual information to the public. Now, we started attacking that, and it soon resorted to the fact that once the minister had compiled his or produced his so-called record, and we said that it could not be complete, we then supplemented our notice of motion and our papers to the extent that we have asked the court to make a declaration that government, and specifically the Minister of Health in this respect, cannot rely on attorney-client legal privilege and is obliged to produce all information and all records pertaining to this decision. This is not something that was followed suit by the other legal practitioners. They have just kept quiet about the whole event because attorney legal privilege is something extremely sacred within the legal fraternity. So if they in somehow start attacking attorney client privilege, legal privilege, it would mean that they are actually doing damage to the legal fraternity itself, which they will never do. So we, as so-called rogue litigants, were the only ones who were able to start to make mention of this extremely serious problem. Because government has been relying on on legal privilege for all these years, and now suddenly, out of the blue, this issue pops up, and now we are attacking it. And we are prepared taking it up to the Constitutional Court and beyond if we need to. And then the other problem came up that we also said, but the record, there should be the court must make a declaration pertaining to the way in which a record should be uploaded to CABLZAJJ system, because you can effectively put any crap and upload it with external databases and external links, but it does not form part of the actual CABLZAJJ's court system. So the court does not have control over the content. In future, if we need to open this case again, they don't have control over the external content. That might vary or be changed at any given time. So we are saying that if it cannot be produced in a PDF or image file, it cannot be uploaded to the CABLZAJJ system. Hence the reason why we said that the government must produce us with a hard copy of the complete record, but they obviously would not be doing it because that would mean that they must supply millions of pages to us. So this whole entire health regulations issue have become a issue pertaining to the legal fraternity and the judiciary of South Africa once again. So instead of pursuing this further, it is easier for government, in order to protect its own mischievous interest in future challenges of any regulations or law. They are more concerned about this very issue, and if we continue at the end of the day follow with our argument and we push through, which we are bound to do, that will as I said, open up a can of worms, a Pandora's box, and it might just lead to the possibility that, and as we've stated, the African Charter specifically does not make provision that the government is protected by legal privilege. So we are using the African Charter a lot within our arguments because our constitution is so flexible in its approach as a result of the Section 36, the limitation of rights clause. And then we also said that the government is not protected by the Bill of Rights because it is government. The Bill of Rights only protect the individual citizens of South Africa and the people in it, in our country, the human rights aspect, and not the rights. Government does not have rights. Government has got responsibilities. And I've seen this argument being argued by, above others, Advocate Wim Trengo for the Minister of Cooperative Governance and Traditional Affairs, Dr. Zuma, whereby he once said that when we challenged her on the contempt of court issues, that she's got a right, in terms of the Bill of Rights, to be reasonably prosecuted. But she was not there in a personal capacity. She was there as a representative of government. And therefore, the Bill of Rights does not extend to government and any of its representatives, like in this very matter, the Minister of Health. So, people, if the government does not have the privilege of not bringing an end to these regulations, they would rather want to compromise the extent of these measures than to, at the end of the day, open the entire legal fraternity to be ambushed at the end of the day, and because of the fact that the government have, or the judiciary has in fact protected government since May 2020, when we've lodged our challenge against the national state of disaster. Although we had this nice 2nd of June 2020 court order in our favor, since then, you could see that every time when we had the right argument, the judiciary came to the rescue of government, and they rather wanted government to appear as changing regulations on their own, but it was always because our arguments were spot on, and they rather wanted to give government the opportunity to relax those very measures than at the end of the day allowing a rogue litigant, non-legal fraternity members to put new meaning in the word of justice. So, people, I just wanted to share this interesting facts with you that's at the background of these reasons. I'm not saying that Liberty Fighters Network is everyone should make a wave, because we are the ones that have resulted in these measures to be changed. I believe that it's a properly attack by the people itself to tell government that we are not allowing you to step over us. We are only a few that are actually coming out and be vocal about this. But at the end of the day, government must listen to us, and we will continue challenging these measures. They will definitely come up with something else in their sleeves, but because they have continually went out of their way to disregard the valid arguments of Liberty Fighters Network, they have run out of ideas. They cannot continue to make adverse findings against proper valued arguments that we are putting forward in court. They know that there's a pattern that have already been established, and if they come out continuing to listen to our arguments on the 25th to the 27th of July, and they might come out and make an adverse finding once again, it's just obvious that the judiciary has then been captured. As we say, it has already been for a very long time. So, people, thank you very much for your support and continued reliance on our work. Really appreciate it. And yes, stay tuned. We'll come back with some other news very soon. God bless until the next time.